Hi, welcome to this Law Study Club video to help you to revise loss of control manslaughter in criminal law for A-level law. Loss of control manslaughter isn't easy to tackle in exams, and it can seem easy to get lost in the different forms of manslaughter. But in this video, we're going to start by tackling that head on with the big picture of the fatal offences before we look at the specific requirements for the loss of control defence. This diagram gives you a brief overview of all of the fatal offences. Now, all 5 crimes on the diagram are fatal offences. Murder is in red, which you probably know means an unlawful killing of a reasonable creature in being and under the King's peace with intent to kill or to cause GBH. The 2 forms of voluntary manslaughter are in blue. What you'll notice is that the actus reus and mens rea are exactly the same for voluntary manslaughter as they are for murder. That's why it's called voluntary manslaughter. There's been an unlawful killing with all the actus reus requirements of murder, and it was done with intent to kill or to cause GBH. The difference between murder and voluntary manslaughter is whether the defendant has what we call a special defence that explains why they had that mens rea, either because they lost control or because they had abnormal mental functioning. Now, the key thing to remember is that these 2 special defences are only part defences. They don't remove the defendant's liability completely, and we're not saying either of them is an excuse for the unlawful killing. It's just that it reduces their level of fault. In this video, we're focused on the first of those special defences, loss of control. Now, the requirements of the defence of loss of control come from section 54 of the Coroners and Justice Act 2009, which replaced an old defence called provocation. And the requirements of the defence are: the defendant must have lost self-control, there must have been a qualifying trigger, which was either the fear of serious violence or things done or said, and then there's an objective test that a person of the same sex and age would have reacted in the same or a similar way in the same circumstances. So the first requirement is that the defendant has lost self-control. Now, we have an authority from R.V. Jewell for the first key rule, which is that loss of self-control must be total. Now, in R.V. Jewell, the defendant shot the victim at point-blank range and was found shortly afterwards in his car with a survival kit, weapons, and his passport. He told the jury at trial, "I lost control, I couldn't control my actions, I could not think straight." But that defence failed because he obviously still had some self-control. He had enough self-control to get together his survival kit and his passport. The Court of Appeal said that for the defence to succeed, there must be a total loss of self-control, and said that the question to go to the jury is, has the defendant lost his ability to maintain his actions in accordance with considered judgment, or has he lost normal powers of reasoning? The second key rule here is that there's no requirement for that loss of control to be sudden. Now, this is different from the old law on provocation, and under the old law on provocation, that loss of control had to be sudden, so the defendant must have snapped in some way. And that was the rule that meant the defence had failed in R.V. Ahluwalia, because the defendant in that case had gone upstairs while her husband was asleep to kill him, so she hadn't just snapped. But her defence would likely succeed under the new law on loss of control, and in fact it was that case that was one of the key reasons why Parliament decided the law needed to change. So then we can move on to the second requirement of loss of control, which is that there must have been a qualifying trigger for that loss of self-control. Now, the qualifying triggers are written into section 55 of the Coroners and Justice Act, and the first is that there was a fear of serious violence against the defendant or another identified person. So that fear of serious violence can't be a generic fear of violence. It has to be either against the defendant or somebody that they can identify. And from R.V. Dawes, we know that fear of serious violence can't be used in defence if the defendant incited that violence in the first place. So in other words, the defendant can't start a fight and then use the fear of serious violence from their opponent as an excuse for having killed them in the fight. The second qualifying trigger we often call things done or said, but in full it says things done or said which were of an extremely grave character and which caused the defendant to have a justifiable sense of being seriously wronged. Now, extremely grave just means extremely serious, and the sense of being seriously wronged that it gives to the defendant must be justifiable. So, for example, if the defendant is accurately accused of a crime and they kill somebody because they've been accused of it, correctly, they can't use this defence because that doesn't give them a justifiable sense of being seriously wronged. Section 55 also gives us some excluded matters that cannot amount to qualifying triggers, and this is just because Parliament has decided that juries might decide these things could count, and they've decided to write into the statute that they definitely don't. So the most important one is that sexual infidelity doesn't count as a thing done or said which causes a defendant to have a justifiable sense of being seriously wronged. So sexual infidelity means cheating on a partner. It might seem a bit strange that Parliament has specifically decided to include this in the statute, but I think it's just because lots of people on juries might decide that that could give a defendant a justifiable sense of being seriously wronged and might decide that it's extremely grave. So Parliament have decided to specifically write in that it doesn't count. But you probably know from R.V. Clinton, the defence can still be available if there is sexual infidelity, as there was in R.V. Clinton, but there are also other things done or said that meet the criteria on their own, which in R.V. Clinton included the victim taunting the defendant about his serious mental health problems. So then the third requirement of loss of control is the objective standard of self-control. So section 54(1)(c) of the Coroners and Justice Act says a person of the defendant's sex and age with a normal degree of tolerance and self-restraint and in the circumstances of the defendant might have reacted in the same or a similar way to the defendant. Now, in some ways, this is fairly straightforward, and it's simply asking the jury whether a similar person to the defendant might react in the same or a similar way in the same circumstances. It becomes a little bit more complicated when we consider the appeal in R.V. Raymansky. So in Raymansky, the trial judge had ruled that the jury was not allowed to take into account the defendant's psychiatric illness when applying this third requirement. The defendant had argued that, because of a psychiatric condition, he shouldn't be compared to a person with a normal degree of tolerance and self-restraint. He should be compared to somebody in similar circumstances who had a similar condition to him. And the defendant appealed on this basis, but the appeal was rejected. So the appeal court said, in assessing the third component, the defendant is to be judged against the standard of a person with a normal degree, not an abnormal degree of tolerance and self-restraint. Now this might seem harsh, but remember that the defendant might be able to use a defence of diminished responsibility or a defence of insanity. It's just that those conditions aren't relevant for loss of control. This is also a good example that you can use for questions about statutory interpretation, as the appeal court is pretty clearly interpreting section 54(1)(c) as it is written. So you should now be able to explain what voluntary manslaughter means and how it fits into the big picture of the fatal offences, and explain how the courts apply each of these three requirements of the loss of control defence: loss of self-control, qualifying triggers, and the standard of self-control. So now let's work through this scenario to check your understanding of loss of control manslaughter. Peter ran a small village shop. Mary, who had previously worked in the shop but had been fired for persistent lateness, launched a group on social media demanding that the shop be shut down. On the group, Mary falsely accused Peter of stealing from his customers and taking photographs of female customers without their knowledge. One day, Mary appeared outside the shop holding a sign saying, "This shop is owned by a thief and a creep." When Peter went outside to challenge Mary, she shouted, "And you used to hit your wife and children." This allegation was also false. Seconds later, and without thinking, Peter punched Mary very hard in the face. She fell backwards into a window and died. Now remember, for a voluntary manslaughter question, you might need to begin by working through the actus reus and mens rea for murder, as these are the same as they are for voluntary manslaughter, but that depends on the wording of the question. A question might just ask you to assess the defendant's liability for murder, so you'll need to do that, but also to spot the possibility of a loss of control defence. Or the question might ask you to assume that there is liability for murder and just to work on the defence itself. If you want to work through the scenario independently, pause the video now and then hit play to get a worked solution. So if we start by constructing Peter's liability for murder, and we start with the actus reus. So the actus reus of murder is an unlawful killing of a reasonable creature and being under the king's peace. Now, Peter has clearly killed Mary, so he punches her hard in the face and that causes her to fall backwards into the window and die. So there's no breaks in the chain of causation, so he has killed her. It's unlawful because it's not in self-defense, and she's a reasonable creature in being and living under the king's peace. Mens rea might be a bit more complicated, so we're looking for malice aforethought, so intent to kill or cause GBH. Now, just because it says without thinking doesn't mean that Peter doesn't have any intention. We can infer the mens rea from his actions. I'd suggest that a very hard punch in the face demonstrates oblique intent to cause GBH, so he knows that really serious harm is virtually certain. And so he's met the actus reus and mens rea requirements for murder, and then we need to look at whether he's met the requirements for the loss of control defence. So we know the first requirement for loss of control is that he has lost self-control, and from RV Jewell that loss of self-control has to be total. Now I would say the clue in the scenario here is that it says that he punched her seconds later and without thinking. That doesn't mean that he doesn't have the mens rea, so he still intends to cause GBH, but it does suggest that he had that mens rea because he'd lost self-control. So now we need to look for a qualifying trigger. So there's no fear of serious violence here. So we're looking for things done or said by Mary of an extremely grave character that give Peter a justifiable sense of being seriously wronged. Now I've underlined things that Mary said and did that on their own would probably fail this test because they're not bad enough, even though Peter would definitely be pretty upset about them. So the demand that the shop be shut down, the accusations of theft or the accusations of taking the photographs, or even the sign that says the shop is owned by a thief and a creep. On their own, they're probably not grave enough. But the comment in green probably does meet that requirement, and used to hit your wife and children. It's an extremely grave accusation of domestic violence, and because it's false, it gives Peter that justifiable sense of being seriously wronged. So certainly when we take that comment in the context of all the other things that Mary has said and done, we have a qualifying trigger. So we're just left with that third requirement, the objective test that a person of Peter's sex and age might respond in the same or a similar way. Now the scenario doesn't tell us how old Peter is, but he's clearly an adult with a business and a family. Now the jury would be left to decide whether a grown man might react in the same or a similar way to Peter in the same circumstances, which they would probably agree with. So the defence would succeed and Peter would be convicted of voluntary manslaughter by loss of control instead of murder. Now remember, that doesn't stop the killing being wrong, and it doesn't stop the killing being unlawful. It just means the court has accepted there was some explanation through his loss of control for why he had the mens rea for murder, so his liability is reduced. Hit subscribe to get notifications on new tutorial videos and follow the link in the description to lawstudyclub.co.uk, where you'll find up-to-date revision guides, case lists and loads more resources for A-level law.